Section 1331 of Title 28 of the United States is a federal statute that provides the basis for federal question jurisdiction in the United States. It grants federal district courts original jurisdiction over civil cases that arise under federal law. Typically, in order to have federal question jurisdiction, the plaintiff's complaint must be a well-pleaded one. This means that the plaintiff's initial complaint must contain references to the federal question and the federal issue evoked. The United States Code's General Federal Question Jurisdictional Provision, Section 1331, gives federal district courts original subject matter jurisdiction over all civil actions arising under the Constitution, laws, or treaties of the United States. In federal court, most civil cases are governed by this act. It is shocking to realize that we don't have a clear understanding of what statutory federal question jurisdiction involves, given the important doctrinal and practical repercussions that follow from assessing whether a claim is covered under 1331. When a plaintiff asserts a substantial claim founded directly upon federal law, Professor Mishkin famously advanced the traditional notion that 1331 jurisdiction exists. However, neither this approach nor any other has been able to convince the federal courts to develop a cohesive theory or practice of 1331. However, this does not imply that 1331 jurisdiction is always a mystery. Undoubtedly, a plaintiff's lawsuit bringing a federal claim will almost always fall under 1331, while a plaintiff's lawsuit bringing a claim based on state law won't. The presence of 1331 jurisdiction is still difficult to ascertain in a sizable number of cases, nevertheless. Federal courts have jurisdiction over civil cases involving federal questions under Section 1331. When a plaintiff's claim is founded on a cause of action that results from the United States Constitution, federal legislation, or international agreements, it becomes a federal question. The federal issue must be significant and really contested in the case. The federal question must be raised in the face of the plaintiff's well-pleaded complaint in order to establish federal question jurisdiction under Section 1331. This means that a federal question must be stated in the plaintiff's complaint as a core part of the claim rather than as a defense put up by the defendant. The federal question must be a significant component of the plaintiff's claim and be grounded in federal law. A federal statute, rule, clause of the Constitution, or treaty can be considered a federal law. If the federal issue constitutes a crucial component of the plaintiff's claim, the lawsuit does not have to entirely concern federal law. Federal question jurisdiction under Section 1331 complements the traditional jurisdiction of state courts. State courts have concurrent jurisdiction over cases that involve federal law, but plaintiffs may choose to bring their claims in federal court if they believe federal jurisdiction provides certain advantages or if there are federal law issues that need resolution. Additionally, the Supreme Court's appellate jurisdiction over matters involving federal issues is established by Section 1331. The Supreme Court has the power to examine and determine matters that lower federal courts or state courts have decided but that contain significant federal questions. If you have any further questions, write them in the comments box, and we'll provide more information. If you or anyone you know violates the law, contact the Department of Labor.